Okay, let's unpack this. Welcome to the deep dive.
Good to be here.
Today we're tackling a really interesting legal knot the Supreme Court had to untangle. Two cases, actually, United States v. Stitt and United States v. Sims.
That's right. And they both circle around the same core question.
Which is?
What exactly counts as burglary under federal law? Specifically, the Armed Career Criminal Act, or ACCA.
Right, ACCA. That's the law that ramps up sentences for certain repeat offenders.
Exactly. And the question here is whether burglarizing something like an RV, a motorhome, counts.
Or, and this came up in the Arkansas case, Sims, burglarizing any vehicle someone happens to be living in.
Mm-hmm. That lives-in provision is a key part of the puzzle. So our mission really is to get into the arguments, figure out what the justices were wrestling with.
And why it matters beyond just these specific cases.
Absolutely, because it touches on how we define common crimes in a federal context.
So the central conflict, just to set the stage, is between different ways of reading burglary for ACCA. Does it include vehicles people use as homes, even temporarily?
Pretty much. You've got this older idea of burglary breaking into a building, a structure.
Right, like a house?
Yeah. Versus the reality that home can be mobile now, an RV, a van.
So the government's take was basically that back in the 80s, when ACCA was written...
Or amended.
Right, amended. That most states would have considered breaking into any kind of home, mobile or not, as burglary.
They argue the law intended to protect dwellings, broadly speaking.
Yeah.
Wherever people live, wheels shouldn't matter.
But the other side, the respondents, they pushed back hard on that.
Oh, yeah. They said, hang on a second. They pointed to past Supreme Court decisions.
What did those say?
Well, the respondents argued those cases drew a pretty bright line. Buildings and structures are one thing for ACCA burglary.
And vehicles are another.
Exactly. Vehicles are out. And they argued an RV, however homey it might feel, is fundamentally a vehicle.
And they really didn't like that Arkansas lives in idea either.
No, they saw that as potentially way too broad. Could a regular car count if someone sleeps in it? That was their worry.
Okay, so it's a clash of definitions, precedent, and maybe common sense versus legal categories. What's really at stake?
Well, it comes down to how the feds interpret state crimes for federal sentencing. There's this method the court uses.
The categorical approach. I've heard that term.
Right. It means the court looks at the legal definition of the state crime, like Arkansas burglary, not the specific details of how someone committed it that one time.
So they compare the state law's words to a kind of generic federal idea of burglary.
That's the goal. But state laws differ, So the justices had to decide. Does burglarizing an RV, or maybe just a car someone sleeps in, fit the generic definition Congress had in mind for ACCA?
Okay, let's dive deeper. Starting with the government's arguments, what were their main pillars?
The government really leaned on history. They said, look, burglary, historically protected dwellings, places people lived.
And back in
86, they argued, most states protected all sorts of homes, including mobile ones, RVs, trailers.
So the common understanding, they argued, already included these.
That was their pitch. They cited a key case, Taylor v. United States.
How did Taylor fit in?
They argued Taylor defined generic burglary as unlawfully entering a building or structure with intent to commit a crime, but that the spirit of it and the state laws at the time meant structure should be read broadly enough to cover these mobile dwellings.
They put a number on it, didn't they? How many states they thought agreed?
Yeah, they claimed something like 44 states back then would have considered RV or mobile home break-ins as burglary.
Wow, okay. But what about the whole it's a vehicle argument? How did they counter that?
They tried to make a distinction. They said, okay, maybe a regular car you just drive isn't a dwelling, but
if it's used differently.
Right. If it's customarily used for overnight accommodation, or if someone actually lives in it, like in the Arkansas law, then it functions as a dwelling.
So use matters more than the object itself.
That was their argument, that states have sort of come around to this modern idea that a dwelling can be mobile if it's used that way.
What about this phrase, adapted for overnight accommodation? Did they define that?
They suggested it implies some changes, maybe a bed, some amenities, but maybe even temporary adaptations could count. It seemed a bit fuzzy, honestly.
So the core government idea is Congress meant ACCA to hit repeat burglars who invade people's homes, whatever those homes look like.
Exactly. And they warned that siding with the respondents would mean a lot fewer state burglary convictions would actually trigger the ACCA enhancement. It would weaken the law's reach, they argued.
Okay, makes sense from their perspective. History, intent, function over form. Now let's flip it. The respondents' pushback. What were their key arguments?
The respondents went straight to precedent. They said, look at the Supreme Court's own words, from Taylor up to a case called Mathis.
And those words said?
They argued those cases consistently separate buildings and structures which can be burglarized under ACCA from vehicles which cannot. Full stop.
So an RV is a vehicle, case closed.
That was their stance. They said it's designed and used primarily for transport, so it falls squarely in the vehicle category the court already excluded.
They didn't buy the government's argument that past cases only excluded, like basic car theft.
No, they argued the court's exclusion of vehicles was broader than that. It wasn't just about stealing stereos, it was about the nature of the place being entered.
And this used for overnight accommodation idea, they had problems there too.
Big problems. They argued that's just too vague, too subjective. Where do you draw the line? A trucker's sleeper cab? Someone napping in their car on a road trip?
It could get messy.
Very. And they pointed out there's no clear federal definition of adapted either. So how would anyone know what qualifies? It creates real fair notice problems.
Didn't they bring up some stats about RV use?
Yeah, they did. Trying to show that RVs are, on average, used way more for travel than as full-time homes. Something like 19 nights a year for lodging, they said, reinforcing the vehicle-first idea.
And they pointed to state laws too.
Right, like Tennessee's law, which apparently has separate definitions for structures, including fixed mobile homes and vehicles, showing that states do make this distinction.
Interesting. They also mentioned something called the residual clause of ACCA, even though it's gone now. Why bring that up?
It was about congressional intent. That clause targeted crimes with a serious potential risk of physical injury. They argued its presence suggested Congress saw burglary itself as inherently risky, likely because it involved entering places where people lived and confrontations could happen.
And breaking into an empty RV is less risky.
Less likely to lead to violence than breaking into an occupied house, they argued. They even cited some studies on that. They said if violence does happen in a vehicle crime, it's usually charged differently anyway. Carjacking, robbery, assault, not just burglary.
Which loops back to their fair notice point.
Exactly. How is a defendant supposed to know if burglarizing this specific RV or that particular car will suddenly count as an ACCA predicate offense?
Especially with that Arkansas law saying just lives in.
Right. They argued lives in is incredibly broad. Could it mean just one night without any adaptation? They felt that clearly went beyond any reasonable generic definition of burglary.
Did they suggest a solution for the Arkansas part?
Yeah, they said maybe the Supreme Court should send that specific question back down, maybe even to the Arkansas Supreme Court, to clarify what their own law means.
So the respondents are pushing for clear lines. Vehicles are vehicles, stick to precedent, prioritize predictability, fairness.
That's the gist.
Yeah.
And they basically said, hey, if Congress doesn't like how the court has interpreted ACCA burglary, Congress can always amend the law, pass a new statute.
It sounds like the justices had a lot to think about. What kinds of questions were they asking? Any hypotheticals that stood out?
Oh, plenty. They really pressed both sides on what adapted means. How permanent does it have to be? Does adding on a mattress count? What about just putting curtains up?
How would a burglar even know?
Exactly, that came up.
Yeah.
How much notice does the potential offender have? There were hypotheticals about people experiencing homelessness living in cars. Or vacation homes, only used occasionally. What about a Winnebago parked right beside a house? Is one burglary and the other not?
Tricky lines to draw.
Very. And the court seemed worried about the government's position potentially sweeping in almost any car capable of being lived in.
That sounds incredibly broad.
It does. And some justices voiced concerns about ACCA's reach generally, the severity of the mandatory sentences. One justice even floated the idea of needing a really clear statement from Congress if they intend a law to have such dramatic consequences.
Did they talk about why Congress used the word burglary in the first place?
Yes. They dug into the legislative history a bit, trying to gauge the original intent. And there was discussion about the court's own, sometimes complicated history of interpreting ACCA.
Were alternatives discussed? Like maybe not using the categorical approach.
Some justices seem to wonder about that, maybe looking at the actual facts of the prior crime. But that would be a big shift from how they usually handle ACCA.
And Congress potentially changing ACCA came up too.
The fact that there's legislation pending to potentially replace or overhaul ACCA was mentioned. It kind of hangs over these discussions.
And that Arkansas distinction customarily used versus lives in, they focused on that.
Quite a bit. trying to understand if lives in meant something different, perhaps broader than regular or adapted use. And they also debated how much deference they owe to how Arkansas state courts might interpret that phrase.
Wow. So this case really puts the whole categorical approach under the microscope, doesn't it? And how stare decisis, sticking to precedent, works when facts on the ground, like mobile living, change.
Absolutely. It's a test of those legal principles. And the outcome obviously impacts defendants facing ACCA enhancements. But it also says a lot about federalism, the balance between state criminal law and federal sentencing.
And the need for clarity in the law, especially criminal law.
Definitely. When you're talking about potentially adding 15 years to someone's sentence, clarity seems pretty important.
Okay, time for our signature segment, the 10th chair. If talk testimonies had a vote on this, if we were the 10th justice, where would we land?
Sitting as the 10th chair, we would likely lean towards affirming the lower court's judgments, meaning we'd likely agree with the respondents.
Okay, why? What's the reasoning there?
Our reasoning would really hinge on precedent, on stare decisis. While the government's historical argument about 1986 has some appeal, the fact is the court has, in multiple cases, drawn a distinction between building structures and vehicles for ACCA burglary.
And RVs fall on the vehicle side of that line.
In common language and in many legal contexts, yes. An RV, a motorhome, is primarily a vehicle, even if adapted for living. Sticking to that established distinction provides more clarity and predictability than trying to parse customary use or adaptation on a case-by-case basis.
What about the Arkansas lives in provision? That seemed particularly problematic.
That's the other major factor. Accepting that lives in could potentially cover any instance of sleeping in a vehicle seems to stretch the definition of burglary far beyond its traditional core and the likely generic understanding Congress had. It feels too ambiguous, too prone to uneven application.
So reinforcing the existing framework.
Pretty much. Our hypothetical ruling would favor maintaining that clearer line between traditional dwellings and vehicles under ACCA. It might mean fewer offenses qualify as predicates, yes.
But it prioritizes consistency with past rulings.
Right. Consistency, predictability, and avoiding an overly broad interpretation of state laws within this specific federal sentencing scheme. It would also implicitly signal, that if Congress wants a different result, a broader definition, the ball's in their court to legislate it clearly.
So this deep dive into Stitt and Sims really shows how complex it can be to apply legal terms across different contexts and times. Burglary seems simple, but
when you mix in federal sentencing enhancements, varying state laws, and evolving ways of life, it gets complicated fast. It's a classic example of the Supreme Court trying to draw workable lines in fuzzy areas.
And as always, a reminder, our analysis, including the 10th chair segment, is just commentary for discussion.
Absolutely. It's not legal advice, and it certainly doesn't represent the court's actual views or final decision.
Definitely something to think more about. We encourage everyone listening to do their own reading and thinking on this one. Thanks for joining us for this deep dive on talk testimonies.
My pleasure. Thank you.